Marcus got pulled over on I-95. He'd had a couple of drinks, maybe 3. The officer ran him through some roadside tests, then asked him if he wanted to take a breathalyzer and said, "I need you to blow into this." Marcus had heard that refusing was the smart move, that no number meant no case. So he said no. 3 weeks later, he had 2 problems instead of 1. A DUI charge based on the stop and a separate criminal misdemeanor charge for the refusal itself. A charge he didn't even know existed. See, refusing a breathalyzer in Florida does not make your DUI case disappear. And depending on your history and based on a change in the law, it creates a brand new criminal charge on top of everything else. Like I said, recently, even a first refusal can bring about a separate criminal charge. In this video, I'm going to walk you through exactly what happens when you refuse a breathalyzer in Florida, what the state can and can't force you to do, and the real trade-off you are making when you say no. When you got your driver's license in Florida, you made an agreement, whether you knew it or not, and that's called implied consent. By driving on Florida roads, you agreed in advance to submit to chemical testing, breath, blood, or urine, if a law enforcement officer has probable cause to believe you're impaired while driving. You never signed the specific paper acknowledging this, but the law treats the act of obtaining a driver's license as that agreement. So when an officer asks you to take a breathalyzer after a traffic stop, they are invoking that very agreement pursuant to the implied consent law. They're calling in the deal you made when you got your license. So what happens when you say no? First refusal, your license is going to be suspended under Florida's implied consent law. It's automatically suspended for a period of 1 year, not as part of the DUI conviction, not after a full court hearing or jury trial. That administrative suspension kicks in immediately. Now, there is a formal process to challenge that suspension, but you have a very short window, 10 days to be exact, with which to request a hearing. If you miss that deadline, the suspension stands regardless of how your DUI case ultimately goes. So refusing the breathalyzer doesn't end the traffic stop cleanly. It actually starts a separate, fast-moving set of consequences, and the clock begins ticking right away. Also, because of a recent change in the law, even a first refusal now brings about a separate criminal charge. What happens if this is your second or subsequent refusal? Now you're facing an 18-month suspension and an elevated criminal charge. And here's the part that most people don't know, and the part that changes the entire calculation for some drivers. If you have a prior DUI conviction in Florida or a prior refusal under the implied consent law and you refuse again, that refusal itself becomes a criminal charge. And now, because of a change in the law, even a first refusal is going to bring about those similar consequences. A separate misdemeanor offense, independent of the DUI, you may also be facing. Now you're not dealing with one charge, you're dealing with at least 2. A DUI charge from the underlying stop and a refusal charge layered on top of that. I've worked with clients who chose to refuse because someone told them, without knowing their history or the change in the law, that it was a smart move. It made an already difficult situation that much harder. If you've refused before, or if you have a prior DUI in Florida, refusing a breathalyzer is not a neutral decision. It carries even more criminal consequences than if it were your first. And you need to understand that before you make that call. Can they physically force you to blow? People ask this all the time, and the answer on a standard breathalyzer is no. Police cannot force you to exhale into a machine. Breath testing requires your active participation, and they cannot compel that participation by force. But they can't force you is not the same as there are no consequences. There's an important distinction here. What police can do and do in serious cases is seek a warrant for a blood draw. The U.S. Supreme Court has addressed this issue. Warrantless blood draws are generally not constitutional, but if law enforcement can obtain a warrant, which in some DUI cases can happen through a phone warrant process in under an hour, they can compel a blood draw even over your objection. And remember, blood draws are more invasive than breath tests. But the BAC, the blood alcohol content result from a blood test, is used just like a breathalyzer result. And at that point, you've already racked up a refusal with its own consequences. In DUI cases involving accidents, injuries, or other aggravating circumstances, Florida law enforcement does seek blood warrants. This is not theoretical. This happens. Can your refusal be used against you? Yes. Under Florida law, the prosecution can tell the jury that you refuse to take a breathalyzer, and they use it every chance they get. Think about it this way. Their argument is very straightforward. If you weren't impaired, you would have had nothing to hide. Refusing shows consciousness of guilt. And that's how they frame it to a jury. Now, that argument has real weaknesses. People refuse breathalyzers for plenty of reasons that have nothing to do with guilt, such as they're nervous, they don't trust the accuracy of the machine, or they have medical conditions affecting their breathing. See, breathalyzer devices are not perfectly accurate and can be challenged, but the refusal comes in front of the jury. That's the reality. In my experience defending DUI cases in Florida, refusal is sometimes the right call for a particular client in a particular situation. And sometimes it can make things significantly harder. There is no single universal answer. It really depends on your history, the circumstances of the stop, and what the state can actually prove without BAC number in evidence. What I want you to understand is that refusal is not an escape route. It is a trade-off. And it's a trade-off you should understand before you're standing on the side of a Florida highway at midnight making a decision you can't take back. Field sobriety tests are a separate question altogether. And I want to be clear about something that trips a lot of people up. Florida's implied consent law applies to chemical tests, breath, blood, urine. It does not apply to field sobriety tests. The walk and turn, the one leg stand, following a pen with your eyes, those roadside tests are voluntary in Florida. You can decline to perform them without triggering any implied consent consequences and without the automatic license suspension. Why does that matter? Because field sobriety test results are frequently unreliable. They're highly subjective, and police use them to build probable cause for the arrest before the chemical test even happens. The less they observe during those tests, the less they have. If an officer asks you to perform field sobriety tests, you can decline politely and clearly. I decline to perform field sobriety tests. That's it. That's the whole statement. It does not invoke implied consent, and what you choose not to do in that moment may matter later. Now, what happens at the station? Here's the sequence a lot of people don't think through. You get arrested. You go to the police station. At the station, they ask you to submit to a breath test using a more sophisticated instrument, typically an intoxilizer. That station test is also covered by implied consent. You can refuse at the station, just like you can refuse at the roadside. The same consequences apply. Now, one detail worth knowing, whether you refuse at the roadside, at the station, or both, and in what order, all of that becomes part of the record. The sequence of events matters to how your case is built and how it's defended. What's the real trade-off? Here's how I explain the actual calculation to clients. If you take the test and your BAC is below the legal limit, well, that evidence helps you significantly. It becomes one of your strongest facts. However, if you take the test and your BAC is over the legal limit, the state now has a number, and that number is often the central piece of evidence in a DUI prosecution. If you refuse, there's no number. That makes the prosecution harder in some respects because they have to build their case entirely on the officer's observations. But you've also triggered the license suspension, and if there's a prior refusal in your history, you've now created an elevated criminal charge with more serious consequences, and you've handed the prosecution a refusal that they can put in front of a jury. Because of that, there is no universally correct answer. There is the answer that fits your specific situation, your specific history and the specific facts of your stop. What I want you to walk away knowing is that a refusal is not a free pass. It is a deliberate decision with real consequences, some of them serious. And understanding those consequences before you make the choice is the difference between an informed decision and a mistake. So let's recap. Florida's implied consent law means driving on Florida roads is treated as an advance agreement to chemical testing. First refusal, 1-year automatic license suspension, and a second-degree misdemeanor. Second or subsequent refusal, if you have a prior DUI or a prior refusal, this criminal charge is now a first-degree criminal misdemeanor, and your license suspension ramps up to 18 months. Police cannot physically force a breathalyzer, but they can seek a warrant for a blood draw in serious cases. Your refusal can be presented to a jury as evidence of consciousness of guilt. Field sobriety tests are different. They are voluntary, and you can decline without implied consent consequences. Refusal is a trade-off, not an escape. Understand it before you decide. And to see how most of these situations actually start, go watch some of our previous videos when encountering police officers.